Hello and welcome back to our YouTube channel. Well, it is lecture number 22 of Indian Polity and it is 7th July 2025. So, in this video we are going to discuss few important concepts related to your Indian Polity. Since from last 22 classes we are discussing Indian Polity, we had discussed various aspects of your syllabus. We discussed what constitution is. We started with that. We discussed special features of our constitution, and in that special features we saw that how our constitution is federal type of constitution, not fully federal, but still we can say it has a federal characteristics. And even we understood that when we discussed the basic structures, that federalism, it is the basic structure of the constitution. But is our constitution really federal in all circumstances? That is what we are going to understand today. Well, before we'll start our discussion properly, let me give you the brief introduction about this initiative, so that if you are new to our channel, you will get more connected with us. Basically from 2nd June, we started an initiative here by the name Target IAS 2026. Under this initiative, we every day try to upload 2 videos. One in the morning session where we discuss your current affairs, and another in the evening session where we discuss the static part of your syllabus. And under evening session, which is this video, in the static part we started with the Indian Polity. We had covered 22 lectures of it. Now we are only left with 8 lectures after this, so we are about to complete it. And here we had promised you that by the month of January 2026 we are going to complete your full syllabus, whatever is required for you to clear your prelims exam as well as your mains exam. But here is an exception. What is that? We are not going to conduct the optional classes here. And one more thing, we always say here that as we are delivering these lectures, at the same time we are preparing your notes. These notes are very much different from your conventional books, because in these notes will contain every topic which is important for your prelims or mains preparation. We'll discuss those topics in a very detailed manner, and after the end of the topic we will give you the example questions or practice questions with respect to prelims as well as mains. But this service of these notes, it won't be available to you guys for free. For if you want to get these notes, you would just have to pay 200 rupees. If you are interested, then only. Otherwise everything would be available here. So for the notes, you just have to mail us and we will respond to it. So this is the initiative what we had started. Now without any delay, let's come back to our discussion and start where we left from. We started, as I told you by the beginning, that we started with the constitution and we discussed the features of the constitution. And we established one fact, that our constitution is a federal constitution in normal circumstances. But in abnormal circumstances, it is not federal anymore. It becomes a unitary constitution. What our constitution becomes, it changes from federal to the unitary constitution. And that is what we will understand here, how it changes from the federal to the unitary constitution. And this we will understand through the emergency powers or through the emergency provisions of our Indian constitution. So here first let's understand this federal structure. For the federal structure, there we need to have the center and we need to have the state. For a country to be a federal country, that if we have the states, these states should get power from whom? Should a state get power from the center, then we call it federal? No, then it is not a federal, it is a unitary, because it would depend on the center, it would depend on the mercy of the center. So for a country to be a state, it should get its power from what? It should get its power from the constitution. So that is the case with our constitution. That is the case with our federal structure, that the center gets its powers from the constitution, same state gets its powers from the constitution, and that is very well defined under schedule 7 of the Indian constitution, where we have the union list which is left for the center, we have the state list which is left for the state, and we have the concurrent list which is left for both center and state, and whatever is left, that is under the residuary list, and that is with the center. So here it is proper understanding here. But let's understand one fact here, that the purpose of this federal structure, or purpose of the states, or purpose of the center, is to govern the country, to govern it, to evolve the country, to uplift the people there, and at the same time to provide them the rights and duties what are what is essential for them. But is it the only thing what is important in a country? Sometimes we may go into a war. Sometimes we may see the external attack into our country, external aggression. Maybe China will attack us. Maybe we will have a war with Pakistan. Or maybe there would be some external aggression from the proxies of China and Pakistan. So at that time, the security of the country is under stress. The integrity of the country is under stress. The unity of the country is under stress when there is the armed rebellion in the country itself. So what would be the focus of the center and the state? Should their focus be on the democratic right? Should their focus be on the fundamental rights to be provided? Should their focus be on give them the right to speech and expression? No, it is not the focus at that time. The focus changes. And what is that focus? The focus changes to protect, to safeguard the security, to safeguard the integrity, to safeguard the sovereignty of the country. So that is the rationale behind it. That is the rationale behind the emergency. So why we have the emergency provisions? So that we can protect, we can safeguard unity, security and integrity of the nation. And this is the rationale behind the emergency. And we know that we have the central list, we have this state list. So who should safeguard it? Now the question is, who should safeguard this security, or who should safeguard the unity of the country, or who should safeguard the integrity of the country? Is it state? Are states capable of doing that? If we look at the 7th schedule, they have limited rights, they have limited items in them. The army is under the control of center. The nuclear forces or nuclear arms are under the control of the center. So who has the upper hand in it? It is the center who has the upper hand in it. So definitely it is the center who should control it, who should safeguard our security, who should safeguard our unity, who should safeguard the integrity of the nation. That is why we have the emergency provisions which give these rights, which give these powers to the center if any case these emergencies are there in our country. Now the question is, this is the basic introduction of emergency, why we have there. Because first, our constitution, it is not fully federal. This is the unique thing about our constitution. We are not fully federal, we are quasi-federal. Sometimes in normal conditions we act as federal, but still there are limitations. But in the abnormal conditions we are not federal at all. We are very much unitary, we are very much under the control of the center. And what is the purpose of that? The major rationale behind it is to protect, to safeguard unity, security and integrity of the nation. So now the question comes, what types of emergencies are there under the Indian Constitution? So that is the discussion of today's class. We'll discuss what types of emergencies are there, and if time permits us, we will also discuss various schedules which are part of our Indian Constitution. So first, let's discuss what types of emergencies are there in our Constitution. Let me rub it first so that we will have a clear board here. The Constitution describes 3 types of emergencies. One emergency is national emergency. Under Article 352 we have the national emergency. Article 352 we have national emergency. Then we have Article 356, we have the president's rule, or we can say president's rule. Then we have Article 360 where we have the financial emergency. So let us discuss them one by one. Let us start with the national emergency. Let us see what types of national emergencies are there. Then we will discuss the president's rule, and then we will discuss the financial emergency. Let us discuss them one by one. Starting with the national emergency under Article 352. What does Article 352 say? Article 352 says, if the president is satisfied, what president is satisfied that there is war, external aggression and armed rebellion, then the president can proclaim the national emergency. So if the president is satisfied that there is war, external aggression or armed rebellion, then the president can proclaim national emergency. So what are the criterias? What are the criterias for the national emergency? The criterias are war, external aggression, and the armed rebellion. Now the question may come to your mind, sir, what is the difference between war and external aggression? You know, as I told you, war is very well defined by the states that we are going into the war. But the external aggression, you know, it may be from anyone. It may be from the non-state actors of the foreign country. For example, non-state actors of the Pakistan or non-state actors from the China. They may come in and they may try to cause chaos in our country. They may try to cause instability in our country. They may try to harm this sovereignty of our country or security of our country. Then it would be called as external aggression. Similarly, we have what? We have the war, external aggression, and we have armed rebellions. It is very much internal aggression. It may be from the Naxalites. It may be from the Maoist. It may be from the internal militancy in Jammu and Kashmir. It may be from the separatists who want to separate their state from the country. So this may be because of them. So this is the idea of the national emergency. What does the Article 352 say? It says that if the president is satisfied, if there is war, external aggression or armed rebellion, the president can proclaim the national emergency. We also understood what is the difference between war and external aggression. So president can proclaim. And what is the satisfaction? What is if the president is satisfied? What is this satisfaction? We know that it is not his satisfaction. It is the satisfaction of the Council of Ministers. And one more thing which can be very much relevant for your prelims here. How many times this national emergency has been imposed in our country? A question about it can be asked in the prelims. It is 3 times. 3 times national emergency has been imposed in our country. It was in 1962. War, when we were when we had war with China. It was 1971, which was India-Pakistan war, and it is 1975. But this 1975 is the most controversial, and because of that, in this 1975, many acts were amended, and it was changed by the 44th Constitution Amendment Act. And we will understand that what was the difference between what earlier used to be and what used to be after 44th Constitutional Amendment Act. So it was 3 times till now this national emergency has been imposed. So this is about the national emergency, how it is imposed. It is president can proclaim national emergency. If today president proclaims national emergency, so from today the national emergency would be imposed. So after this, what will happen? Let's try to understand that what is the validity of the national emergency, how it can be revoked, and all that we will discuss here. So what is the validity of the national emergency? Let's try to understand it. First, the president will proclaim. Once the president will proclaim, within 1 month, it needs to be approved by the Lok Sabha as well as the Rajya Sabha by the special majority, by 2/3 majority present at and voting. So what is the how it is valid? What is the validity of the national emergency? First, the president will proclaim it. Second, within 1 month, it should be approved. It should be approved by the both houses of the parliament by special majority. It should be approved by both houses of the parliament by special majority. Then it will continue. Once they will approve it, then it will continue for 6 months. For how much time? It will continue for 6 months. So after the 6 months, what will happen? If they want to revoke it, it would be revoked. It will not be passed by the both houses, or both the houses will stop it. Or if they will not revoke it, then it will continue. It will continue. How long it will continue? There is no limit for the extension. Why? Because we don't know. We don't know how far the war will continue. How far the war will continue. You know, recently we had seen such incident, even though the national emergency was not imposed, but there were chances that we might had gone into the war with Pakistan, where it would have been full-fledged war, and we don't know how long it will last. So for that, there is no limit on it. It is then there are conditions how it can be revoked. there is a difference between the national emergency and the president's rule. In the president's rule, where when we will discuss that, we will see that it has a limit. Maximum time period is 3 years. But in the national emergency, there is no such limit. Now let's see how it is revoked. Here we understood how it is, how it is proclaimed, how it becomes valid, and how long it becomes valid. There is first it will be passed, it will be proclaimed by the president. Then it will be passed by the special majority by in the both houses of the parliament. Then it will stand for 6 months. After 6 months, it will continue like that. The both houses of the parliament will pass it. How long? There is no such limit. Now let's see how it will be revoked. How it will be revoked. Let's try to understand that. These are very conceptual topics, and not that conceptual, but these are very much factual topics which you have to remember, which can be relevant for your prelims exam. So how is it revoked? How is it revoked? That is the kind of question which is very much important for you. First, it can be revoked at any time by the president himself. He can say, if today he will proclaim that there is a president's rule. After some time, he may come back and say that there is no president's rule. It is up to him. He can revoke at any time. Can be revoked at any time. At any time by president, and for this he has to consult the council of ministers. It would be their satisfaction, not his satisfaction only. Then another way how it can be revoked, if either house does not approve. Suppose if it is passed by the Lok Sabha after 6 months and Rajya Sabha rejects it, then it would be revoked, and vice versa. If either house does not approve it, or if both houses does not approve it, it would be revoked. Third, we have the judicial review for that. Judicial review. Under this judicial review, the judges, the courts, Supreme Court will discuss it. They will study it, and they will analyze it, whether it was whether this proclamation of emergency was under the intentions of mollified, whether the intentions of the president were good or bad. That would be understood here. And then we have the special power to the Lok Sabha under Article 352 clause 8. What are these special powers? That if this will not be revoked, then what are the special powers? The 50 MPs of Lok Sabha, they will write either to speaker or they will write to the president. For the speaker to let's have a discussion over the emergency, and for president to call the meeting, convene the session of the Lok Sabha, and there the discussion about the emergency will happen, and then the voting will happen. In voting, if the resolution is passed by the simple majority, then it is revoked. If the revocation of the emergency resolution is passed by simple majority, then it is revoked, and that resolution is binding on the president. So that's why it is called the statutory resolution. It is binding on the president. So this is how it is revoked. It can be revoked at any time by the president himself. If he will not revoke it, then the legislature can revoke it. The parliament can revoke it, either by either house, either by Lok Sabha or Rajya Sabha. Or if that will not also happen, then the judicial review will be there to check the mollified, to check the intentions of the president. And not even if by the judicial review, then it can also be revoked by the Lok Sabha under the Article 352 of clause 8, where the 50 MPs will write to speaker or president to convene the Lok Sabha, and there they will discuss over it and they will vote over it. And if they win by the simple majority, then it is revoked. So this is how it is revoked and how it becomes valid. Now let us see what is the impact of the national emergency on the country, on the place where it is being imposed. Let us see what is the impact of the national emergency. Impact of national emergency. The first impact will be, seen by the fundamental rights. First one is on the fundamental rights. So how it will impact fundamental rights? If there is external aggression or war, if there is external aggression or war, then impact would be different. What would be the impact? The impact on fundamental right under Article 19, their enforcement is automatically suspended. Enforcement of fundamental rights under Article 19 will be suspended. So what is this? This article will not be suspended, but the enforcement of it will be suspended. That you can, if this thing is not available to you, if this article is not available to you, if this right is not available to you, you cannot go to court for that under the external emergency. And it is very much understood, it is very much justified. For example, if there is external aggression, there are bombs are going on, and you will not be allowed to come at the place come together at some place, protest there, it will impact your security itself. So it is very much justified that this article the enforcement of this article is suspended. That is, your right to approach under this article is suspended. And what if it is for the external aggression? What is the situation for on the armed rebellion? If there is armed rebellion, then Article 19 is not automatically suspended. Then that means under armed rebellion, Article 19 is not automatically suspended. President can use Article 359 and suspend other fundamental rights. Here, but if armed rebellion is there, Article 19 is not automatically suspended. For that, the president can use Article 359 and suspend other fundamental rights, suspend all fundamental rights. But there is exception. What is this exception? Exception is of Article 20 and 21 of the Indian Constitution. Except these articles, none can, except these articles, every article can be suspended by the president if there is armed rebellion, and it could be done under Article 359. So this is the impact on the first impact on the fundamental rights. Now let us see how it will impact the legislature. Let's have a look at how it is going to impact the legislature. Who is going to make the laws for you if there is national emergency? Let's have a look at that. Or the Lok Sabha, how it is going to impact the second impact on legislature. We have this, either we have the state legislature or we have the Lok Sabha. They are going to make make the laws for you. But during the national emergency, what will happen? That once there is national emergency, that the time period for example, after 4 years of the Lok Sabha or 4 years of the Legislative Assembly, there is some national emergency imposed. Then what will happen to national emergency? Will it be dissolved? No, it will not be dissolved, but its term will extend. Its term will extend till there is national emergency. It will keep extending. Once the national emergency is revoked, then they will be given 6 months. After that, it will be dissolved. After 6 months, there will be new elections. So what is the impact of national emergency on the legislature, on the state legislature or the Lok Sabha? Its term will extend till 1 years, till the national emergency is there. Once the national emergency is revoked, then they will be given 6 months. After that, the state legislature or the Lok Sabha will get dissolved. This is the first impact it will feel. Then what about the power to make laws? What about the power of the legislatures to make laws? Then here we have the difference. What is that? For example, earlier in the normal conditions we have 3 lists. We have union list, we have state list, and we have the concurrent list. In the union list, union will make laws, center. In the state list, center will make laws. In the concurrent list, both center and state can make laws. But during emergency, what happens? In emergency, there are only 2 lists. One is union list and the another is concurrent list. What is that? In the union list, it is the union who can make laws. In the concurrent list, it is both union and state. So what happens? Those in the state list which are in the normal conditions, they will turn into the concurrent list and they will be aggregated into the concurrent list. Now whatever was in the state list and the concurrent list, that will be confined in the concurrent list, and it is both the center and the state can make laws on these concurrent lists. And here we know that if the center makes law and the state makes law, and if they contradict with each other, then the center's law will prevail. So this is what will happen with the law making powers of the state legislature, that it will be divided. It will be this will be divided into the center list and union list and the concurrent list. So that means that the parliament can make laws on land, they can make laws on agriculture, and if the state legislature try to block those laws, then the state legislature will be dissolved. And also with respect to this, the union the center will issue the directives to the state, and state will be forced to accept those directives. They cannot reject those directives. So this is what will happen during the emergency. And about this national emergency, please remember a few points. It can be imposed even in one part of the state or full nation. It can be imposed in, and the power can extend to any state, even which are not in emergency. What is that? For example, if the emergency is imposed in suppose if the emergency is imposed in Tamil Nadu. Suppose emergency is imposed in Tamil Nadu. The nearby states, there also, if the center will make any give some directives, then the state will have to accept those directives. So the power of the center, it extends to any states which are not in emergency but which are neighbor to this emergency states. So this power of the center during the emergency, if there is emergency in any particular state, this power of the center will extend to other neighboring states too. So these are few important points which you need to know for your prelims exam. Now we know that the emergency till now was imposed for 3 times. One was imposed in 1962, then the another was imposed in 1971, then the third was imposed in 1975. The most controversial is of the emergency of 1975. We know that how it started. We discussed that there was election, and in the Raj Narayan case, where the Indira Gandhi won, but he went to the Allahabad court that she won by doing malpractices. Then the Allahabad court, they dismissed her. Then she went to the Supreme Court, and Supreme Court stayed order for her, and with the condition that she cannot vote in the procedure in the Lok Sabha. But then after that, there was a person, Jai Prakash Narayan, who wanted to get rid of her, but eventually the emergency was imposed. This emergency, it was most cruel emergency. There were violation of human rights, many people were arrested, and laws like MISA were imposed. So there were many changes were done with the Constitution. 42nd Constitutional Amendment Act was introduced. So with respect to this, people were not satisfied with her, and eventually in 1977 this emergency was revoked, and there were elections, and finally the Janata Party won. And when the Janata Party came in, they brought up the 44th Constitutional Amendment Act, and they changed the key provisions with respect to the emergency, and that we will understand here now what was the initial picture of the emergency and how it was changed by the 44th Constitutional Amendment Act. Let's try to understand that. Let me make 2 columns here. Here we will see what was the previous provisions and what was by the 44th Constitutional Amendment Act. So earlier there was the 3 ways of the emergency were the external aggression, then the second one was war, and the third one was called as internal disturbance. It was called as internal disturbance. But this internal disturbance, it is a very vague term. It is not well defined. So it was changed to it was replaced by the armed rebellion. It was replaced by the armed rebellion. If there was, before before 44th Constitutional Amendment Act, if there was any any law and order issue, then the president would have proclaimed the emergency because they would have called it internal disturbance. But by the 44th Constitutional Amendment Act, it was changed that it will be called as armed rebellion. So this term was changed. Second, earlier it would have been it would have been proclaimed by the oral advice of the PM, oral advice of PM. Now it was changed by the written advice of the cabinet, written advice of cabinet. So it was the first time, before 44th Constitutional Amendment Act, you cannot see cabinet in the constitution mentioned anywhere. It was the first time the cabinet was introduced, and with this respect that it would be the written advice of the cabinet. So it was first time cabinet was introduced, written in the constitution. Then third change which was made, earlier it was once approved, continues for ever unless revoked by the president. It was there, once approved, continues for ever unless revoked by president. But it was changed to now continues only for 6 months. There would be periodic parliamentary discussion over it. So now it will continue for 6 months. Then the Lok Sabha and Rajya Sabha will decide whether they want to continue it or not. So here you can ask me a question, sir, in the discussion what you told it can continue forever. Yes, it can continue forever. There is no upper limit for it, but by the permission of the Lok Sabha and the Rajya Sabha. Here now the fourth change. What was the fourth change? The fourth change was in earlier what used to be the both Lok Sabha and Rajya Sabha will approve within 2 months by simple majority. They will have to, both Lok Sabha and Rajya Sabha will approve within 2 months by simple majority. Now it was changed to within 1 month by special majority. And earlier what used to be all fundamental rights were dissolved, all fundamental rights were dissolved, and now not all fundamental rights are dissolved. Article 20 and 21 will always remain here. Earlier there was no scope for the judicial review. Now there is the scope for the judicial review. So these are the changes which were made through the 44th Constitutional Amendment Act. And a kind of question, a mains type of question can be asked with respect to the emergency, how the 44th Constitutional Amendment Act changed the history of the emergency, and why after the 44th Constitutional Amendment Act we don't see any emergency, any cases of national emergency in our country. So these are the changes which were made through the national emergency. So here we complete our discussion with the national emergency. So here what we did understood in the national emergency. First we saw that who is the authority who can proclaim it. It is the president. Is it the satisfaction of the president? No, it is the satisfaction of the Council of Ministers. It is once the Council of Ministers gets satisfied, then only he can proclaim the emergency. Then it should be within 1 month. It should get the approval from both houses of the Parliament by this special majority. Then it continues for the 6 months. Then there is no limit for it, but the shape continues, the structure of it continues, or we can say the way it is it is accepted, it is approved by the both houses of the house, both houses of the Parliament. They have to continue it further, then only it can continue. Then we discussed how it can be revoked. It can be revoked by the president. It can be revoked by either of the houses if they will not approve the bill. Then it can be revoked by the judicial review also, and by it, and the Supreme and Lok Sabha has a special power under Article 352 Clause 8 where it can revoke it. Then we saw that effects of the national emergency. We discussed it on the fundamental rights, how the Article 19, if there is external aggression, how the enforceability of the Article 19 is suspended. Then we saw if there is armed rebellion, how it is not automatically suspended, but the president can impose by the use of Article 359 and can suspend the fundamental rights, but there is exception, that is Article 20 and 21 cannot be suspended. Then we saw that impact on legislature. For example, with respect to state legislature or the Lok Sabha, if there is national emergency, then it will not be dissolved. It will continue for next year. Once the emergency would be revoked, within 6 months they will be dissolved, and then the elections would be there. And also we saw with the lawmaking powers of the legislature how earlier we used to have the union list and the state list and the concurrent list. Now we have only two lists, that is union list and the concurrent list. How it becomes. And finally we saw that how it can be it can be imposed even in a single part of the state, and also we discussed that how its power extends to the neighboring states of the how during the emergency the powers of the president extend to the neighboring states also, how the center can instruct them during the emergency. And then we discussed what were the changes brought forward by the 44th constitutional amendment act. With this, I hope you had understood the national emergency very clearly. Now let's move to the president's rule, which is under article 352. Let us discuss the president's rule now. President's rule under article 356 of Indian Constitution. So when this constitution was framed and this provision was discussed, what Dr. Ambedkar thought? Dr. Ambedkar thought, he believed that this provision will never be used. It will always remain a dead letter, that it will never be used. But unfortunately, this provision of the president's rule, it has been used more than 130 times. More than 130 times it has been used since the enactment of the Indian Constitution. So where from this idea of president's rule is there? First we have article 355. Article 355, what does it say? It says that it imposes a duty on the union that they have to protect the state from external disturbances and outer aggression, and also ensure governance is carried in line with the constitution. So this is what the article 55 says. Then we have article 356. What does article 356 says? It says that if the president is satisfied on the basis of the report of governor or otherwise. What does article 356 says? It says if the president is satisfied on the basis of the report of governor or even otherwise, here this term is very much to be discussed, then there is a breakdown of the constitutional machinery, that there is a breakdown of constitutional machinery, then the president can then the president can go for the presidential rule. Then the president can impose article 356. Then the president can impose article 356, which is the president's rule. So here what did we understood? If the president is satisfied, is it the satisfaction of the president himself? No, it is the satisfaction of the council of ministers on the basis of the report of governor or even otherwise. Either it would be the report of the governor or even otherwise. What is this even otherwise? It can be anyone. It can be the IB report. It can be anything. Can it be the recommendation of High Court? That we will discuss. Here it is a question. No, it can't be the recommendation of the High Court, because it was once the Arunachal Pradesh High Court, they tried to do it, but it was stayed. Not Arunachal, Andhra Pradesh High Court tried to do it, but it was stayed by the Supreme Court. So it can be the report of anyone. It can be the report of the governor. It can be the report of the IB. It can be a report of anyone. If the president is satisfied that there is a breakdown of the constitution, then he can impose the president's rule. So let's see how long will it continue. Now here you had understood, if the governor gives the report that there is the breakdown of the constitution in a particular state, or any authority or any body gives the report that there is a breakdown of the constitution in particular state, then the president can impose the president's rule. So let's see first how long it how will it be imposed and how long it will be imposed. What is the limitation of the president's rule? Let's have a look at it. Let's see the structure of the president's rule. First, The president will proclamation of the president. Then within 2 months, the Lok Sabha and the Rajya Sabha, within 2 months of the proclamation, both Lok Sabha and Rajya Sabha shall have to approve president's rule by simple majority. Will approve president's rule by simple majority. Then what will happen? This president's rule will be there for the 6 months. After 6 months, can it be extended? Yes, it can be extended further for the 6 months, so it will contain 1 year. And after these 6 months, can it be extended? The answer to it is no as well as yes. Why no? Because the limit would be only because it cannot be imposed that far. Why yes? Yes is because maybe the election commission will say that they are not in a position to conduct the elections, or there is national emergency has been imposed. Once it is yes, then it can be increased to 2 years more. This will be imposed to for 2 years more. It will be there for 2 years more. After that, there cannot be this president's rule will finally end. So what is the age of the president's rule? It is 1 year plus 2 years, which is 3 years. First 1 year it is normal. Then for the next 2 years it would be the it will depend upon the conditions, whether election commission is ready to conduct the elections, or if there is national emergency. Then the maximum time limit for the president's rule is 3 years. So this is the 3 years. This is how it is proclaimed. Now how it is revoked? Revoked at any time by president. First, at any time by the president. Second, if not approved by parliament. Third, in case of judicial review. If there is judicial review, then it cannot be approved. And these are the ways it can be revoked. First, it can be revoked by the president at any time. Second, if it is not approved by both the houses, then it is revoked. Then third, if both the houses approve, but it can still go to for the judicial review, and judiciary, they will decide what was the aim of the president. So after that, we have to discuss what is the impact of president's rule. What is the impact of the president's rule? Here the impact would be on the executive wing as well as legislative wing. The executive powers goes in the hands of the president, and the legislative powers goes to the center, and they will the president or the agent of the president will govern the executive power, which would eventually be the governor. Here the center or their agent will make the laws for the during the legislative wing. So these are the changes which will happen. But as we discussed that the Ambedkar, when this was discussed, he thought that this would be least used provision in the constitution, but it has been highly misused. So let us see why it is being misused. Misuse of the president's rule. Let's try to discuss that, why it has been misused. Misuse of president's rule. Here we understood that there is a term mentioned, breakdown of constitutional machinery. Breakdown of constitutional machinery. And this breakdown of constitutional machinery, it is not well defined. When it is not well defined, so it will lead to different interpretations. When it will lead to different interpretations, then definitely there are chances that it would be misused. And we had seen also during the emergency, when there was, after the emergency, when Janata Party won, and in the they won the election and they came into the power, and in the 9 states where the Congress was ruling, what they did, they dissolved the, they imposed the president's rule. They dissolved the legislative assembly is there. So when after the Janata Party, when Indira Gandhi came into power again, she did the same. So it was very much, it was done very much on the basis of what? On the basis of the interests of the government. For changing the, for changing the governments, it was brought in, and there were huge malified intentions behind the president's rule. And finally, this was solved under the SR Bombay case. Under the SR Bombay versus Union of India case, it was solved, and courts, they gave the few important provisions which are to be followed, in which we can see that this has not been misused, or it is used properly. So let us see what are these provisions which were given. Let's try to discuss that. What is the proper use and what is the improper use of this article? First, let's try to build the narration, build the story for the BR, SR Bombay case, why it came into the picture. After in 1992, there was a demolition of Babri Masjid. When there was demolition of Babri Masjid, there were chaos in the country, in different states. For example, there was chaos in Gujarat. There was chaos in Maharashtra. There was chaos in Madhya Pradesh, and at the same time there were issues in the eastern states like Nagaland and Mizoram. And at the same time, the SR Bombay, who was the CM of the Karnataka, he did not enjoy the full majority, but he was CM because there were a lot of alliances to him. So what happened one fine day, the governor, he got letter from MLAs that they don't want SR Bombay to be the CM, so please remove him. What governor did? He removed him. And SR Bombay approached him, why did you remove? He told the governor told him that he had received the letters from the MLAs that they don't want to continue their support to you. So he said that those letters are false. Then eventually he was removed from the CM and there were new elections. But still, the case went to the Supreme Court, and when this case went to the Supreme Court, at the same time there were various states were under pressure. The MP government, it was also dissolved. So these all cases went to the Supreme Court, and they were all clubbed together, and the case became the SR Bombay versus Union of India case. So under this case, different things were discussed for the president's rule. The intentions were discussed. First, what was discussed? First, the Supreme Court upheld that the federalism is the basic structure of the Indian Constitution. And second, what was upheld? That there would be the judicial review. There would be the judicial review. So, when federalism, when there would be the judicial review, and we know that it was the governor who has, how, let's try to understand how this president's rule will be imposed. Here it would be the governor. He will send his report to the president that the constitution, here is the breakdown of the constitution at any particular state. Then what will the president do? He will send it to the cabinet of ministers for the meeting. They will discuss it, and then the home ministry, they will send the report back, and they will give the advice. They will give advice whether to go for the president's rule or not. So here in the judicial review, what was decided, that this advice, it cannot be reviewed, because under Article 78 of the Indian Constitution, it is very much clear that you cannot, under Article 74 of the Constitution, it is very much clear that you cannot review this advice. But what the judiciary did, they said that on what matter this advice was given. What was the matter? What happened there? So on what matter this advice was given, so this matter would be studied. This matter would be studied whether it is genuine, that this thing what had happened there, whether this matter is genuine to go for the president's rule. So it was the first thing which was established there. And also, one is the president's, second thing, one is the president will claim the President's rule. So, suppose president claims president's rule, and within 2 months the Lok Sabha and the Rajya Sabha will have to accept it. Suppose they disagree. So can in this 2 month period can they dissolve the legislative assemblies? No. The Supreme Court said no, they cannot dissolve until the Lok Sabha and the Rajya Sabha they approve it. So these were the two changes which were brought in with respect to this. And finally, it was decided that there are this article it can lead to the proper use, and it can lead to the misuse also, improper use. Now let us see how it can be the proper use and how it can be the improper use. And it also defined that if there is the, for example, there is a law and order issue that cannot be deemed as the constitutional breakdown of the constitutional machinery. So it should be very much defined, it should be very much clarified. So let us discuss how it can be the proper use and how it can be the misuse. Proper use. So how it can be proper use? First, on the grounds of breakdown of constitutional machinery, this president's rule should be given on the grounds of breakdown of constitutional machinery, but not on the grounds of the breakdown of law and order, order. For example, if in a particular state there is the breakdown of law and order, then they cannot impose president's rule and say that there is the breakdown of constitutional machinery. No, it is not same. These are two different things. Law and order is different and constitutional machinery is different. So it was highlighted. Second, what was highlighted? Second thing which was highlighted is if the secularism is violated. Secularism is violated. For example, in the case of the Madhya Pradesh government, they believed that there was law and order issue, so our statehood can be restored. Our legislative assembly can be restored, but it was not, because the Supreme Court said that secularism was violated in your state, so it can be the reason for the president's rule. Then suppose there is clash between tribes in particular states, for example in Manipur, and also there is no chief minister, then the president's rule can be imposed. Similarly, in Jammu and Kashmir, where there is no chief minister, and then there also the chief minister in 2018, then the president's rule was imposed there also. Fifth, if there is hung assembly, then the president's rule will be imposed. And the seventh, the states violate the directives issued by the central under the Article 365, then the president's rule will be imposed. So these are the proper use. This is the proper use of the president's rule. Now let's see what is the improper use of the president's rule. Let's have a look at the improper use of the president's rule. Improper use. First, there is in the improper use, you will not differentiate between the law and order breakdown and the constitutional machinery, constitutional machinery breakdown. You will not differentiate between them. If you are not able to differentiate between them and you are mixing the two, then definitely there is the improper use of this president's rule. Second, if there are corrupt charges against the minister and you are imposing the president's rule, then it is the improper use. And also, if you are imposing the president's rule for the change of a government in particular state, then it is the improper use of the president's rule. For example, if at the center BJP has won, and in the legislative assemblies elections, in the Lok Sabha elections, BJP has won from Jammu and Kashmir. But suppose in the legislative assembly in Jammu and Kashmir, the PDP government won. Now what will BJP decide? What will BJP do? They will say that in the Lok Sabha elections they had won. Now they will dissolve the parliament. They will dissolve the legislative assembly in Jammu and Kashmir and tell them to go for the new elections. So this is not allowed now. This is the improper use of the president's rule. And with this, the president's rule is over. So this is under Article 356. Now there is third emergency, which is called the financial emergency. there is third emergency, which is called the financial emergency. It is under Article 360. How many times this financial emergency has been imposed in India? Was it imposed in 1992 crisis, in 2008? No. The financial emergency has never been imposed in our country. So we don't know what will happen exactly if the financial emergency is imposed. What does the Constitution say about the financial emergency? The Constitution says the President can proclaim if he is satisfied that if he is satisfied that the financial stability or credit of India or any what does the Constitution say? Let me make it very much simple. If the President proclaims that there is a financial emergency, then there is a financial emergency. And what would be the conditions for that? If he is satisfied, is it his satisfaction? No, it is the satisfaction of the Council of Ministers that there is a breakdown of the financial stability and there is the issues with the credit of India. There is the breakdown with the credit of India or any part of the territory in India that is threatened. For example, if there is threat on the financial stability, threat on financial stability of India or threat on the credit of the India, and if the President is satisfied, then he can invoke the financial emergency. For example, we are not able to pay loans. We are not able to pay loans. We are under huge balance of payment crisis is going on in our country. So there we can impose the financial emergency. And what would happen? We don't know what will happen after that. But one thing is very much clear, that we will take the austerity measures. For example, they reduce the salaries of any class of person in the center who is working for the center. We will reduce the salaries of those persons. Any bill which is passed in the parliament, that would be reserved for the President, whether it is the money bill or any other bill, that would be reserved for the President. And this about the financial emergency, how long it can be stand? It can stand forever until it is revoked by the President. Financial emergency, it can remain there forever until it is revoked by President. And how it is passed? First, President will proclaim, and within 2 months, Lok Sabha and the Rajya Sabha will approve it. After the approval, it can remain there until the President revokes it. So this is the financial emergency, because there is no much discussion about it. It has never been imposed. So it becomes very much important for your prelims preparation only. So with this, the emergency part is over. Now let's have a look at what type of question can be asked in your exam. The question I had brought out is with respect to the financial emergency. So let's try to solve it. Here the question says, which of the following statements about the proclamation of the financial emergency under the Article 360 of the Indian Constitution are correct? First statement, a proclamation of the financial emergency can be issued by the President of India if he is satisfied that the situation has arisen whereby the financial stability or credit of India or of any part of the territory thereof is threatened. 100% correct, nothing wrong with it. Second, once approved by both houses of the parliament, a proclamation of financial emergency continues indefinitely until revoked by the President. That is also correct. Third, during the operation of a financial emergency, the President can direct the state to observe canons of financial propriety and reduce the salaries and allowances of all or any class of persons serving in connection with the affair of the Union, including the judges of the Supreme Court and High Court. 100% correct. So with respect to this question, all the three statements are correct. So with this, we had completed today's discussion with respect to the emergency. Now, yet we have time. Let's start our discussion on the schedules. So let's start the discussion on the schedules. What are the different schedules in our Constitution? There are 12 schedules in our Constitution. Let's discuss them one by one. Let's see how far we can go in today's discussion. So what we have to discuss now? We have to discuss schedules. So let's see what is schedule. We can say it is a commentary or explanation of the article. It is the explanation of the article. There are 12 schedules we have. So let us discuss them one by one. What is schedule 1? What does it contain? Schedule 1, it contains names and details of the names and details of the UTs. Names and details of the UTs. This is what schedule 1 contains. Schedule 2, it contains salaries and emoluments. Schedule 2 contains salaries and emoluments. For whom? For the president, for the vice president, for the speaker, for the deputy speaker, for the deputy chairperson, for the judges of the Supreme Court and High Court, for the CAG, for president and governor. It contains the salaries and emoluments. So this is what schedule 2 is about. Schedule 3. What does schedule 3 talk about? It talks about the forms of oath and affirmation. Forms of oath and affirmation. Oath is for the believer, affirmation is for the non-believer, which we had already discussed. For example, for the ministers, for the CAG, for the judge, the oath and affirmation would be under schedule 3. But here is an exception. What is the exception? The oath of president, vice president, the oath of president, vice president and governor, they are the part of the constitution. They are not under the schedule. The oaths of the president, vice president and governor don't come under the schedule 3. So this is the oath of forms of oath and affirmation. Then what does schedule 4 talk about? Allocation of seats in the Rajya Sabha. Schedule 4, allocation of seats in Rajya Sabha. How many seats would be for the UP, how many seats would be for Jammu and Kashmir, Tamil Nadu, whatever. So schedule 4 would be the allocation of seats in the Council of State or in the Rajya Sabha. Now we have schedule 5 and schedule 6. These are here we need to give a little understanding about these schedules. Schedule 5 and schedule 6. In our country we know that we have the tribal areas. It is very much clear. We have tribal areas, and it is believed that they are the most indigenous to India. It is believed that when Aryans came, they were the people who lived in India, and they were pushed towards the forests. They did not want it to mix with the Aryans. So this is one of the belief that advent of Aryan into India. So when the constitution was formed, there was discussion about how they will treat these tribal people. To treat them, we cannot force them to act like us. So there was a consensus that let them live their lives depending upon how much tribal they are. So in this regard, we have the tribals except from the states of Assam, Meghalaya, Mizoram and Tripura, except the tribals who are from the states except these states, they come under the schedule 5. And the tribals of Assam, Meghalaya, Mizoram and Tripura, they come under schedule 6. So there is protection given to them. And in the 5th schedule, what kind of protection? Here is economic protection. Economic protection is given to them so that their economy will be protected. If anybody wants to buy land in the tribal area, they will have to take the permission of the of the governor there. They will have to take the permission of the they will have to take the permission of the governor. They will have to take their permission. So that is how the 5th schedule is. And for the 6th schedule, there is extra protection, and it is not only the economic protection but also the religious, the cultural, and all that protection would be given to them. They will be allowed to make laws, whether criminal laws or whether civil laws. They will have their own criminal and civil laws. In the 5th schedule, we have the Tribal advisory committee, we have tribal advisory committee. In tribal advisory committee there would be 3/4 member of the tribal advisory committee would be the tribal MLAs, and the remaining would be nominated by the governor, and they would advise about any law formed by the center, that whether they should apply this law there or not. And in the sixth schedule we have the autonomous district councils. We have autonomous district councils. In these autonomous district councils, 25 will be the tribal members who will be elected by them, and 4 would be nominated by the 4 members would be nominated by the governor, and they will decide whatever laws they have to make with respect to the sixth schedule with respect to these tribes. So in nutshell, the fifth schedule and the sixth schedule deals with the tribals. The fifth schedule deals with every tribal except the tribals from the Assam, Meghalaya, Mizoram and Tripura. Sixth schedule deals with these tribals. In the fifth schedule, the concern is basically the economic. In the sixth schedule, the concern is much more wider. In the fifth schedule, we have the tribal advisory councils, in which the 3/4 members are the MLAs from the tribals, and the rest is remaining is nominated by the president, by the governor. In the sixth schedule, we have the autonomous district councils, in which 25 members are elected and 4 are nominated by the governor. The autonomous district councils, they can make laws for themselves. They have the legislative wing, they have the executive wing, they have the criminal laws and all that. In the fifth schedule, they will advise the governor whether to accept the law made by the center or the state in these territories. So this is about the fifth and sixth schedule. It is about the tribals. Now we have the seventh schedule, which we are discussing from the day one. Which seventh schedule, which deals with the distribution of powers under Article 246 of the Indian Constitution. And under the seventh schedule, we had discussed that there are three lists. We have the union list, we have the state list, we have the concurrent list. In the union list, it is the center which will make law. In the state list, it is the state which will make law. In the concurrent list, it is both center and state. But suppose if there is state makes any law and center makes any law, and it is violative of each other, then the center's law will prevail. Now suppose if there is already a state law, center law, and the state will also want to make law on that subject, then it will go for the president's recommendation, and president will approve it, and eventually it is the council of ministers which will approve it. So this is how the schedules work. And with respect to it, further understanding, we will discuss it when we will discuss the center-state relations. So this is the seventh schedule. Now after that we have the eighth schedule, in which we have the official languages. We have 22 official languages. Earlier, what was the official language? In the eighth schedule we have the 22 official languages, and in it English is not part of these 22 official languages. What is the official language of the Union of India? Earlier it used to be Hindi in Devangiri, script, but there prior to Hindi, it was English. Both Hindi and English could be used at the same time for 15 years after the commencement of the Constitution. And in this period, after every 5 years and 10 years, they will set up the committee and who will review whether we are ready to imply the Hindi as the official language. But once BR Khar committee was created, which would discuss it. But in 1960, another committee was to be created, but that was not created because of the agitation, anti-Hindi agitation in the Madras, in various South Indian countries, South Indian states, and because of that, finally the government passed the law called the Official Languages Act 1963. Official Languages Act 1963. Under this Official Languages Act 1963, it made clear that Hindi and English they will be they will act as the official language of the country, and there is no limit on the usage of the English up to what time period it can be used. For the states, what is their official language? It is up to them to decide. The states will decide what is their official language. So here comes the concept of the linguistic federalism. They will decide on their own what will be their official language. Can they go for the language which is not part of the 8th schedule? 100% they can go for this language which is not the part of the 8th schedule. So with this, I will like to conclude today's discussion. I hope you would have liked the video. I hope you had understood everything. If there is any confusion, please let me know. I will try to reach out to you. And rest other schedules, 8th schedule, remaining 9th schedule, 10th schedule, 11 and 12, we will discuss in the upcoming classes. 11 and 12 we will discuss when we will discuss panchayat and municipalities. So be connected with us. We are about to complete our syllabus for Indian polity, and if you want to get access to the notes, please do reach us through email. We will definitely send you the notes. With this, thank you for staying with us. Thank you very much and have a nice day.